Hello, ladies and gentlemen. I'm here to talk to you today about the Eighth Amendment. Get my show started here. I decided to focus on the Eighth Amendment because of the number of court cases involved in one particular clause of the Eighth Amendment. So let's go ahead and get started talking about this. So the origins of the Eighth Amendment really were to limit the criminal justice system's sanctions on those accused or convicted of criminal behavior. The amendment reads, very similar to the English Bill of Rights of 1689. Now, the U.S. Constitution, ratified, passed in 1789, states excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. If we look at the English Bill of Rights, the language in the English Bill of Rights from a century previous is almost identical. Excessive bail ought not to be required, excessive fines not imposed, nor cruel and unusual punishments inflicted. So the Founding Fathers were simply restating rights that they themselves were already protected under with the English Bill of Rights from 1689. Now, in terms of what does this mean? Well, the amendment simply means that in relation to fines, the Constitution, however, let me back that up. So in terms of fines, we are protected against excessive fines. However, the Constitution does not define what excessive means. The rule generally has been that fines not violate due process that results in loss of property. So fines can be high, but the courts are very careful to make sure that maybe the individual has time to pay off the fines, they have payment plans, things of that nature. Now, some people might say, well, wait a minute, people go bankrupt defending themselves. Well, that's different than a fine for a crime. Now, bail is where you start to see larger monies. Not that fines cannot be exorbitant, but the courts are very careful to keep fines within the due process and not resulting in the loss of property for an individual. But when we look at bail, individual rights of the person accused can be tempered with regard to the interests of the legal system and society at large. The seriousness of the crime, the evidence against the accused, as well as their flight risk are always taken into consideration. When you see bails set in excess of like $1 million or $5 million, the seriousness of the crime is taken into consideration as well as their risk of flight. Many times bail is not allowed, and that is due to usually the seriousness of the crime as well as the amount of evidence against the accused. You tend to see that in murder cases. Now, the part of the amendment that tends to be most discussed and argued would be the cruel and unusual punishment clause. Now, the Constitution does not define what cruel or unusual means. The courts have been left to determine that. And there certainly have been a lot of cases to determine what cruel and unusual may mean. The idea is that punishment should fit the crime. And in many cases, the punishment in our court system is anywhere from spending time in jail, spending time in prison, and then, of course, the death penalty. And so the idea of capital punishment is something that is questioned as, is that part, should that be included under the cruel and unusual punishment clause? So I'm going to focus on capital punishment since that seems to be the one thing generally that is questioned the most. So in 1791, when these rights are passed, the capital punishment was legal for crimes such as burglary, larceny, and fraud. I mean, if you stole someone's horse, you could be hung for that. If you were fraudulent in who you were, and if you passed bad checks, passed yourself off as someone else, or said you were going to do something and then you didn't, that would be fraudulent, you potentially could be found guilty of capital punishment and punished for that with your life. It's not until almost a century later that you start to see limits. So in Witten versus Georgia, the Supreme Court ruled that limits were permissible. To a certain standpoint, they start to define that the cruel and unusual clause, specifically for punishment, was intended to, quote, prohibit the barbarities of quartering, hanging in chains, castration, etc. And so we know in England, those were certainly punishments that you would see. We saw those. Unfortunately, those punishments in the United States, there just didn't really seem to be, the court had not come out and said what is cruel and unusual, and so they define it as barbaric, quartering, hanging in chains, castration. To put someone to death for a crime was still considered legal as long as it was not barbaric. Then in 1890, we have In re Kemmler, and for those of you who may not know, In re simply means in the matter of. Kemmler. Kemmler was an inmate in the New York State Penitentiary System. He had been found guilty of murder, and he was sentenced to die in the electric chair. The electric chair had come about as a wonderful new tool in which capital punishment could be meted out. It was supposed to be painless, and it was supposed to be instantaneous. However, there were some that did not agree with that. There was some evidence that it was not instantaneous and painless. However, that evidence was not really shown to the court. In a 9-0 decision, the Supreme Court said that death was instantaneous and painless when using the electric chair, and that Kemmler could be electrocuted, and he was. They specifically said lingering deaths were what the cruel and unusual punishment clause prohibited, which were burning at the stake, crucifixion, breaking on the wheel, or the like. Which means hanging was still legal. Firing squad was still legal. Those were seen as not cruel and unusual, although hanging was not always quick and instantaneous. You hoped that the firing squad hit the mark. Sometimes they did not. But those were better than burning at the stake, crucifixion, breaking on the wheel, etc. So then we see in 1972 a 5-4 landmark decision. Now it takes almost a century for the Supreme Court to come down and really start to limit the use of capital punishment in the United States. So the court actually combined 3 cases into one under Furman v. Georgia. And in each of these cases, we have individuals who murdered somebody, and maybe the acts were not considered heinous. In one, Furman v. Georgia specifically, a man was breaking into a home, and the homeowner was trying to get him, and in getting out, the assailant apparently, or the burglar, Furman, apparently had a gun in it. He says it accidentally discharged. Although his statements didn't exactly always make sense, but he said it was an accident. But he was still convicted of murder and sentenced to die in Georgia's electric chair. He takes it to the Supreme Court, as well as 2 other cases, one from Georgia, one from Texas, and the court, in a very divided decision, says that death sentences violate the Constitution and the cruel and unusual punishments clause. They said that there was too much discretion in meting out death sentences. States were not, each state decided how an individual was to be put to death, and that there were people being put to death, like Furman, potentially for accidental murders. There really was no set standard in which Who qualified? It was murder. Well, we all know there are different degrees of murder, and so the court says that until states can come to a decision on how they should punish individuals with the death penalty, the court put a moratorium on capital punishment. Well, immediately states go back, their state legislatures meet, and they start to figure out ways in which that they can still keep capital punishment on the books, but in a way that the court will see as constitutional. They do a pretty good job of this because in Gregg v. Georgia in 1976, just 4 years later, the court in a 7-2 ruling reinstates the death penalty. Now, the Furman v. Georgia is important to note because a lot of people who were on death row actually had their sentences commuted to life in prison. One very famous one, Charles Manson. So the Furman v. Georgia decision actually prevented him from being electrocuted or put into the gas chamber in California. Gregg v. Georgia comes in. He cannot go from being on death row back to the death penalty. Unfortunately, I shouldn't say unfortunately, he was, and along with others like him, were protected. They could not go from life in prison back to death row. Now, other limits to capital punishment. Things kind of go on. There's a lot of debate, but it's not until 2002 that the court rules that the death penalty is unconstitutional for the intellectually disabled. That was a 6-3 decision. And then just a few years later, there's a 5-4 split decision where the court says that it's unconstitutional to impose capital punishment for crimes committed while under the age of 18. Previously, the age of 16 was the threshold. The court rules 18 is the new threshold. And this actually overturned statutes in 25 states, including Virginia. There have continued to be almost biannually cases that come to the court. In 2015, or come to the court regarding capital punishment. We have Glossop versus Gross, another split decision, 5-4. They rule that the method of execution, lethal injection specifically, is constitutional. And prisoners must prove that there is a better alternative. Since this decision, the court has really stayed away from any appeals to the death penalty. They step away from it and allow states, individual states, to decide whether or not capital punishment within the borders of the state is constitutional. They have said in the earlier decisions in 76 that as the states really did a nice job of figuring out what crimes specifically should be seen as capital crimes. And there is one more decision that comes down in 2016, which further shows that the courts do limit some of the powers, especially the powers of the judges. And in 8-1 decision, juries are the only ones allowed to impose the death penalty. No longer were judges allowed to impose the death penalty. So if someone is going to be found guilty and then sentenced to death, the jury in which found them guilty must also impose the death penalty. No longer is it up to one individual. It is up to a jury of the individual's peers. So I hope you've enjoyed my video. I hope it's been informative. Enjoying watching the other videos, and look forward to seeing everybody else's. Thank you so much. Have a great day.